work on the legal protection of privacy, and more specifically on the development of privacy from within the common law. And what I want to do in this talk is to talk about three questions which I've looked at sort of as phases of my career that all relate to that particular issue. The first is, how did the common law evolve to protect this important interest? And then how did the courts that are applying new privacy actions respond to and shape social norms? Oh, thank you. And then the third question is, what do the developments that took place in the law of privacy and the common law tell us about legal change in general and some of the directions that we might want to head in the future? So the first question, how did the common law evolve to protect privacy? Well, I thought, because I'm not in a law school, I'll start by telling you what is the common law, because I think that might be a little bit of a, I think it's a bit of a mystery from the outside. So at its simplest, the common law is judge-made law. So it's the law of the courts. And it's been built up over centuries, as Richard mentioned, by judges deciding which of the two parties in front of them should win the dispute in question. And each time the judge does that, they give reasons. And the reasons, or at least part of the reasons, become the law which gets carried forward. And that law is binding in the same way that a statute would be. Now, the law of precedent means that usually judges have to follow their previous decisions, but common law is nonetheless, and slightly perhaps counterintuitively, very good at responding to change in society's values, and indeed at driving that kind of change. And that's what happened with the law of privacy. So I'm going to give you a little bit of an example using the names of my colleagues and my husband who are in the room in vain. So let's imagine that Yvette, who's sitting in the back here, sued me because I published without her consent a personal letter which she'd written to me. Now, the judge in that case decided that Yvette should win and gave detailed reasons for her answer. Now, the next time somebody comes along and publishes a letter without somebody's consent, then they'll go back to the Nicole and Yvette case, and they'll probably reach the same conclusion based on the reasons that were given in that case. So if Richard publishes a letter about Tim in similar circumstances, that precedent will hold. Now, it might seem difficult to be difficult to see how anything could change in a system like that because it's precedent focused, but it does, because in reality, things rarely happen in exactly the same way twice. So let's take another example. Let's imagine that rather than a letter which Tim wrote to Richard, Richard picks up a letter which dropped out of Tim's pocket as he was walking along the street, and he publishes that instead. People are always very careless in hypothetical law situations. So he picks up this letter which Tim dropped, contains personal information, and he publishes that, and Tim wants to sue him. So now the court says, well, hang on, we've got the Nicole and Yvette situation, but that was one where the letter was written to the person directly, and this one's slightly different, because it was dropped on the ground. So at this point, things start to get contestable. So you say, well, in that first example, is the key thing the relationship between Nicole and Yvette? Is that the key thing? Or is the key thing the personal nature of the information that was dropped, that was in the letter? Now, the first one is what you call a breach of confidence analysis about confidentiality and relationships between parties. The second one is much more focused on the nature of the information, which is more of a privacy analysis. So there's a fresh value call in that judgment, even though they're applying precedent. And that's how things can change. Now, in the privacy area, this is how we moved from a situation where there was no privacy protection in common law to one where there was. Because the courts looked in at these breach of confidence cases and increasingly began saying, actually, the relationship between the parties is not the key thing here. It's actually the nature of the information that's the most important. And over time, those shifts became more and more pronounced until the courts felt they're in a position to be able to say that actually we do protect privacy as a separate interest. So in a way, I guess they found a new principle that was lying dormant within the case law that had been built up in the reasons of these stories over time and took us off in a new direction. Now, a lot of my academic work in the early days was about why the courts should do what I just described. I first studied media law as an undergraduate at Canterbury University back in the 1990s. And back then, the legal protection of privacy was very limited, and social discourse about privacy was very limited. It's quite hard to remember that there was a time when that was the case. And the media behaved accordingly. So think of the hounding of Princess Diana, if you're old enough to remember, the gratuitous outing of gay MPs, unchecked behaviour by paparazzi. So even as an undergraduate, I shared the views of academics and law reformers who wanted better protection against this kind of behaviour. I thought it was concerning that because they were faced with such significant pressure from the media themselves, legislators just kept on failing to respond to calls to end this kind of gratuitous commodification of people's lives. And I was particularly concerned about that when people were innocent of any kind of wrongdoing and even sometimes injured, vulnerable, or traumatized. It seemed to me back in those days, and it still does, that the commodification that those people were suffering, the way in which they were being treated as something to be used or to be made money out of or to be laughed at, was at least as serious or had at least as much impact as other legal wrongs that we did sanction. And it was felt important that we recognise that as some kind of legal interest. So when I came to write my PhD on the protection of privacy in Cambridge in the early 2000s, at which point there was no protection of privacy in the common law, I decided that we could define that interest as having as the idea of freedom from unwanted access. That what we're talking about is an ability to retreat away from the inquiry and observation of others when we want to. And that privacy is about the ability to say sometimes we don't want to be looked at or found out by people who are wanting to do that to us. And also during that time was when I was part of a number of us were saying that when we look at the common law through a different lens, through the lens that I described in those cases that those hypotheticals I was looking at before, you can actually see this value being recognised by the judges in the cases already. It was just waiting for the right societal and legal conditions for it to be recognised. So that's the first kind of phase that I want to talk about in my work, this phase of sort of discovering this interest lying dormant. The second one is once the interest got recognised. And it was recognised in both of my sort of what I call my home jurisdictions, the UK, where I spent a lot of my academic life, and here. It was recognised as being something that could be protected by the law of tort. And so this, what we call a tort is a civil wrong. So essentially, the branch of law that allows you to sue somebody if they wrong you by running into your car or injuring you in most jurisdictions. So here we ended up with a privacy tort. It's got two key requirements. The first is the existence of facts in respect of which there is a reasonable expectation of privacy. And in New Zealand, we also have to show that there was publicity given to those facts that would be considered highly offensive. And then if we do have a right to privacy, we balance that against competing interests, particularly the right to freedom of expression. So the second phase of my career in privacy was working out how the key elements of this action should be applied. How do you work out whether someone has a reasonable expectation of privacy? Can you have privacy in a public place? How do you work out whether privacy or freedom of expression should prevail, and what kind of remedy should you get? Now, the court in this phase also continued, of course, to respond to social norms, because social norms have a big impact when you're trying to work out whether something's reasonable. They have a big impact when you're working out whether something's highly offensive, and likewise when you're trying to work out whether or not something's in the public interest. But also, of course, when courts are making these decisions, they're also shaping social norms, because courts, when they make the law, make things illegal. And if something's illegal, it's sending a very clear societal message that it's not acceptable. So all of this so the law at this point is kind of absorbing social norms, but also pushing conversations forward that society needs to have and contributing to them as part of a cycle, which is one of the fascinating things I find about legal academia and legal analysis, that there's this cycle of influence as well as absorption. And that brings me to the last the last phase. So the phase this is where I am at the moment, largely. This is looking at pausing and saying, okay, well, what does what happened in privacy tell us about the law, the common law in particular, as a whole? How can we apply some of the style of change in the wider legal environment? I'm interested in particular in two aspects here. So the first is, what does it tell us about how common law responds to social values, how does the societal values, and also other external factors which were at play in the privacy development, things like human rights legislation or international instruments that come in from the outside. And the second question that I'm interested in taking forward is, are there other principles that might be lying dormant within the common law waiting to be discovered in the way that I argue that privacy was. And these two questions are going to be sort of underpin some Marsden funding, which I managed to sneak in and get at the very last minute, the last round. I didn't know that at the time. At one point we were talking about delaying it for a year. I'm very glad we didn't. And this is this project that I'm leading called Death's Impact on Privacy, Reputation and Mana, Researching Pākehā Law and Tikanga Māori. And in this one, I'm going to argue that there's another dormant principle perhaps lying waiting to be discovered. And in this case, it's all about the way in which the courts respond to family members who are seeking to protect the privacy of somebody who has died. So a family member who's died. So what happens in these cases is that often the court will treat an interference with human remains or with the memory of a loved one. They'll treat that not as a breach of the privacy of the deceased, but as a breach of privacy of the people who care for the deceased, so the loved ones. Now, in some ways, this is treated as an aberration, but I actually want to explore the idea that this reveals a very interesting idea of the connected self within the common law. So another thing, because common law has traditionally been regarded as very individualistic, but here we see this recognition of inherent connectivity, and courts haven't really done that consciously. I think they've done it by accident because they're trying to reach the right result in the case. It's a bit tricky to decide what you do about somebody who's passed on. And so they have, and so I'm trying, again, is this another one of these ideas that we can pull out? Now, alongside that work, my two co-investigators are going to explore how tikanga Māori protects mana after death. And the idea is that we bring those two strands together to create a very detailed case law of how tikanga and common law might work together in this particular instance. And we're hoping that that might illuminate in some ways the relationship between the two systems as a whole. And I'm hoping that in undertaking that work, my years of looking at the development of privacy will help me understand how common law can respond to shifting societal values, but also to influences which are, at least for now, largely external to it. And if that's the path that's chosen, how we can help affect the societal as well as legal change that might usher in.
Thanks, Nicole. Any questions?
Yes.
It works.
Oh, it's for recording. Oh, thanks so much. Very interesting presentations, Richard and Nicole. Just a quick question. In relation to the privacy law, in the modern day, given the fact that a lot of our private identity information and so forth are being accessed and available to the big IT companies, and there's so much online. And question is, how does the privacy law respond to that in terms of protecting your identity and privacy aspects of things? The links to the my one question has two parts. That's the first part, and the second part is for Richard. Looking at what's happening in the United States, where the intersection between politics and legality and the legal system is unraveling all over the place, really, in many ways. So you have the economic history, the political history, and legal history all tangled together in a massive chaos, if you like, under Trump. So from the point of view of the legal history, what challenges does it pose in terms of having neat lines between, if you like, the legal, the political, and the economic, and the social? So just a couple of questions there.
Do you want to go first, Richard? Or do...
Yeah, bearing in mind we have to move on.
Okay.
All I can say in terms of the second part of your question is that, of course, many lawyers in the United States are paying great attention to their own traditions of their own legal histories as a response to the current political configurations in the United States, by reference to the United States Constitution, to the earliest Supreme Court decisions with respect to that. So, if anything, the study of legal history has become even more powerful, more important than ever in the United States context. So that is pivotal and is widely seen to be.
On the question about online privacy, I mean, I think that the response to the invasion of privacy online requires multifaceted systems. The common law that I described this work I developed before the internet. That's when I first started doing it. It's particularly well suited to an environment where you've got a society where you've got the media exposing people in that society, and you're all operating under the same jurisdiction. All of the laws that I just described still apply when you're online. It's just they become a lot harder to enforce when you're dealing with cross borders. And then when we're talking about the way in which tech companies operate, there you've got multiple small interferences which are happening repeatedly, and that's why those responses tend to require quite detailed regulation, cross-border legislation. But the reality is that it's got to be a multifaceted response to a very broad-ranging problem. Was there someone at the back, or is there time? Yeah, sure.
But thanks very, very much, Nicole.